People versus Mitchell, 114. Counsel, rebuttal time?
2 minutes, please, Your Honor.
2 minutes, sure.
Brendan Boutel, Essex County Public Defender, arguing on behalf of Scott G. Mitchell. The Appellate Division's ruling that CPL 410.80, Subdivision 2, divested the Essex County Court of its ability to hear the appellant's 440 motion completely ignores decades of established case law regarding...
So what do you say the statute did?
Excuse me?
What's
What
the
do you
purpose?
say that the statute did? What was it intended to do?
CPL 410.82 was, if you look at the amendments in some of the commentaries, was to simplify the transfer of probation interstate. That used to be the practice where a transferring court could retain the jurisdiction to handle the violations, to do the resentencing. And that practice proved cumbersome, especially with a transfer from one part of the state all the way across the other state, where the receiving county, say in Erie County, would have to go back to Essex County to get a warrant signed and to have the violation heard.
So what's transferred under the statute? Because the bill jacket does talk about complete transfer of jurisdiction.
Well, it's important to look at some of the definitions, especially with regards to Penal Law 60.01, Subdivision 2, talking about revocable dispositions. And it talks about a revocable sentence should be considered a final judgment of conviction, but it can be altered.
Okay, I'm still confused. What are you saying Essex County can do, and what are you saying Franklin County can or can't do?
Transfer of jurisdiction, I believe, is transfer jurisdiction relating to the supervision and disposition of that portion of the revocable sentence, the probationary sentence.
But it doesn't say that in the statute, right?
It doesn't say...
It wouldn't appear to be limited to that if you just looked at the language, or would it?
If you completely ignore any of the prior history of 440 motions of jurisdiction and also of the statute 410.80, it would appear that way, but I mean, there's some common sense and practical implications of that strict reading to say, I think as my...
Okay, so if I'm on parole and my parole officer finds me with alcohol and it's a condition of my parole that I'm not supposed to be drinking alcoholic beverages, where is that parole violation brought? Essex or Franklin?
In Franklin County. That's where the court that encompasses the Franklin County Probation Department, that would be the court that would have the jurisdiction and power to hear the violation, and if it was sustained, to then resentence that individual.
But if the defendant, if the claim of the defendant was, Judge, you confused me with someone else and you got your docket numbers mixed up and you gave me a sentence that doesn't relate to the plea that I entered, where would that one go?
That is almost identical to the facts of the case Stitham v. New York City probation. That is where the defendant argued that one of the terms in his probation was an illegal sentence. And the court in Stitham said, well, you're talking about an illegal sentence, and that is something that has to be pursued in the court that entered the judgment of conviction.
So that would go back to Essex County.
Correct.
The statute has changed since Stitham was decided, though, hasn't it?
That is true, Your Honor.
And one of the changes was the words "the powers and duties" were changed to "all powers and duties."
All powers and duties, I think that is what's caused this confusion here, is it does give the impression with the word all powers and duties, but that would alter this Court's ruling in People v. Wurzler that in all the cases that follow it, that the only court that can entertain a writ of quorum nobis.
Well, doesn't the legislature have power to alter People v. Wurzler if it feels like it?
I believe the history of the statute is silent as to any other powers that it was attempting to grant the receiving court with. I mean, the statute does explicitly...
And the history, I mean, I guess you're making a case, and it's a reasonable case, that they didn't really plan to do anything that wasn't relating to probation. The trouble is, that isn't what they said. I mean, how far can we go in reading their purpose into the statute when they use these seemingly unqualified words, all powers, sole jurisdiction, of the sole jurisdiction in the case?
I think I would point the Court to Penal Law 65, Subdivision 2, in the last sentence, which it talks about, the Court may modify, enlarge conditions, or revoke probation. I think when they're in the subdivision is headed by the word sentence, when they say all powers and jurisdiction over the sentence, I think that's what they're intending, is the sentence meaning the probationary sentence, and the powers that are enumerated in Penal Law 65, Subdivision 2, the enlarge, revoke, or modify the probationary sentence.
You're really arguing they meant something other than what they said.
I think it's jurisdiction, I think, is one of those words that every attorney wrestles with since day one of law school. It's a...
Jurisdiction it may be complicated, but the word sole is usually thought to be pretty clear.
I think with the prior practice where the court that entered the conviction in the sentence had retained the jurisdiction to do the revocation or to modify the sentence, that's what they were trying. They're trying to make it as clear as possible to wrestle out of the hands of the few judges that still wanted to have complete and absolute control over a probationer that left his court. I think the legislature was being overly clear. I don't know if that's a problem, but it's created the issue here is it makes it clear.
They were trying to avoid any ambiguity, and they went too far.
Yes, sir.
410 that you're talking about, I mean, it's entitled transfer of supervision of probationers. It's not talking about transfer of, for example, sentencing, which I think is the point you're trying to make. If you wanted to complain that the judge was asleep or was not paying attention or something in your 440, it would make more sense to make it to the judge that you're challenging it to than to some judge who has absolutely no idea what you're talking about.
Yes, sir. I mean, carried to some absurd examples with the appellate division's ruling, if your probation was transferred immediately on sentence, under their reading, you would have to file your notice of appeal in the receiving county, a court that had no trial jurisdiction over the offense. And, example of, probation transferred to Erie County from Essex County, if you had to file a 440 motion in Erie County and they were granting a hearing, all the files, all the witnesses, all the people necessary for the hearing are in Essex County. It creates this...
So the appeal could be brought in a different department?
Correct.
I mean, say New York County, and it was transferred to Erie County for purposes of probation or whatever, pursuant to the statute.
I think under the
Your appeal would then have to be heard by the Fourth Department as opposed to the First Department?
Correct.
What would your rule be? I know your red light's on. So only those issues which pertain to the supervision stay in the second county, the
The
county
supervision
where
over...
the supervision's been transferred, everything else goes back to the first county?
Correct. Anything that relates to the underlying conviction, the judgment of conviction and sentence, that is always going to be in the county that entered that conviction and sentence.
Okay. Thanks, counsel.
Brian Feldman with the Essex County District Attorney's Office. I think the irony here of my argument is I'm actually arguing on behalf of something that could create a lot more work for myself. But I do this because I think the law is clear here. And when we talk about,
Go ahead.
Do you agree with your adversary that it's probably not what they meant? It may be what they said, but it's probably not what they meant?
I don't know, because you look at the addition matters specified in Article 23 of the Corrections Law. So that relates to certificate of relief from disabilities. So that would be a post-conviction remedy that was referenced in the statute.
Yeah, but that's equally small too. I don't think they were talking about that when they did it. But your opponent makes the point. I mean, if you get sentenced down in Long Island and now you're going to school at the University of Buffalo, and so you ask that your probation be transferred up there, and the judge signs the order, do you then appeal to the Fourth Department instead of the Second?
And again, I think when the appellate division referenced the logistical issues, I think that's exactly what they were referring to. But again, yes, it would go to that department. That would be our position.
Are both Essex County and Franklin County in the third department?
They are, yes.
But in Judge Piggott's case, if you made if after the probation was transferred, you made a motion based on juror misconduct to set aside the conviction that had been had back in New York City, a judge in Buffalo, you'd have to transport all the jurors up to Buffalo and have the judge in Buffalo hear them on whether that was juror misconduct in a trial before the judge back in Brooklyn?
Yeah, and again, there are logistical issues with this. Again, logistical issues from my standpoint as well.
No, and it's not just logistical. I mean, you have a judge who presumably knows the case and who's disabled from hearing it, and you have a judge who's never heard of the case who has to figure it out.
Right.
Would it make sense to treat, as I think your opponent's arguing, that what meant by sole authority, et cetera, in 410 stays in 410 and 440 stays with the judgment court?
Again, I just don't. I don't agree with the opponent here. I just think the law is clear here, where that court retains sole jurisdiction of the case.
Would it be an unreasonable reading to suggest that when it says we're talking about transfer supervision of probationers, that's what we're talking about, and we're not talking about the judgment itself, the judgment conviction itself?
Again,
That would help you out.
Yeah. Yeah, I think that's fair.
If we disagree with you, then what remedy should
Disagree
we
with
consider?
in terms of the appellant.
If we agree with your
Then
adversary, what remedy would?
It would revert back to the Essex County Court, and Judge Meyer would hear the 440 motion on the merits.
It does make sense that if forgetting these laws, I mean, he wants to say, you judge, when you sentence me with a prior DWI that wasn't a prior DWI. Wouldn't that judge want to correct that?
Yeah, but again, you dismiss it, but you look at the corrections law, Article 23, with the Certificate of Relief from Disabilities. Wouldn't you think that the court, that of the original judgment, wouldn't he be in a better position to?
But aren't they ministerial?
I don't think so. I mean, it is a post-conviction remedy, which, obviously.
Well, you get them in ACDs all the time.
It doesn't go to the judgment. It's sort of a collateral thing. It doesn't really go to the judgment itself or to the sentence.
But it could be factors that went into that, I do believe.
Usually you look at the criminal history report, you look at the probation report, you look at what the person's been doing since, and determine whether or not they're entitled to the Certificate of Relief from Disabilities. But
My experience, maybe I'm wrong, was that most of those come from ACDs,
Most of.
Certificates of Relief from Disability. You get your case is adjourned and then it's dismissed, and then, well, no, you wouldn't even need a certificate then, would you, because it's dismissed and sealed.
Yeah, well, being in the North Country, Essex County, most of the Certificate of Relief from Disability has to do with hunters.
Getting a very important point.
They are in the North Country.
Yeah.
So your position is basically, it says what it means what it says. It may cause some logistical problems, but it's what the legislature did.
That's correct, and it does affect us too. I don't necessarily want to lose power over my 440. I don't want to spend hundreds of hours working on a case where the 440 gets pulled over to Franklin County and their district attorney's office assumes responsibility for responding to my 440 motion. I have a lot of faith in the Franklin County DA's office, but it is something that
If we wanted to read the statute in a less literal way, we wanted to draw a line between the stuff the legislature was talking about and the stuff it wasn't talking about, is there a nice, clean line that would be easy to draw?
I don't believe so.
What's wrong with just drawing it at 410?
You mean just the 410 remedy being brought in Essex County?
Right, saying everything having to do with probation is over there. The file goes, everything goes. So if there is a violation of probation, it's handled there. If, all the little things that happen in the course of probation, it doesn't have to come back to Essex. They'll handle it there. But in terms of attacking the judgment itself, on a 440, it goes back, because you're the one that got the conviction. That's the judge that heard it. Wouldn't that be harmonic?
Yeah, but then you go to the statute again, and the sentencing court shall forward its entire case record to the receiving court. That does
forward a copy of it.
Right, but
Do we have
again,
faction machines?
going to the express language, I mean, it does
And I suppose there are things in that file that might be relevant under both 410 and 440?
Right,
You might need the same piece of paper for both kinds of application.
right.
So they might need to send the file back.
But you can see a difference between supervision and the attack on the underlying conviction itself, can you not?
Yes, I can see that distinction.
It also helps to protect against the defendant moving around the state so that offices or judges that aren't as familiar with that person's case would be handling the case, doing a bit of forum shopping, perhaps.
Yeah, absolutely. And again, I think that does revert back to the third department reference to the logistics, and there are logistical issues with this. But again, I'm interpreting the clear language of the law.
Particularly, it pops into my mind, you talked about the North Country. I would tend to bet that the judges in the North Country know their defendants better than those, let's say, in the city of New York.
That would be very true. Very fair assessment.
Okay. Thank you, Counsel. Counsel?
The 44010, the very first sentence in subdivision 1 says, any time after the entry of a judgment, the court in which it was entered may, upon motion of the defendant, vacate such judgment. So, there can only be one court that enters the judgment.
So those are in conflict. A literal reading of 410 and 440 are in conflict unless we treat the 410 as only speaking about supervision of probation.
Yes, sir.
Well, you would harmonize them. The two statutes is what you want us to do, right?
Yes, Your Honor.
What about the problem of having you can't have the same file in two places?
There will always be a copy available, but it's the witnesses.
There are fax machines in both counties, no doubt.
Yes, Your Honor. But the police that investigate the crime, the grand jury that heard it, the district attorney's office that prosecuted, all the elements that went into creating the conviction or the judgment is in the county, or the transferring county. So there can only be one county that enters the judgment, the conviction plus sentence. I mean, the receiving county, they may resend someone to prison, but that judgment is only revoking what part is the revocable part of the sentence of the probation.
And getting back to the files issue, I mean, we obviously bring up the files from the trial courts when we review a case. When we finish with it, we send it back. That's not a problem.
Correct, Your Honor.
Okay, thanks, Counsel. Thank you both.